About 15 years ago, when I was still actively practicing law, I had agreed against my normal practice to act as the healthcare agent for a client who I'll call Jane. It's not her real name, of course. Jane had just recently retired from a career in the publishing industry and moved to Madison from New York to live. She had no family or friends in Madison, and in fact, she had a distant relationship with her other family members that were out of town. As it happened, she was interested in a particular aspect of World War II history that also interested me, and so we hit it off quite well. And so at the time I agreed to become her healthcare agent, she was in remission from cancer, a fact that I did not know. Although I raised the topic from time to time, I could never get Jane to talk about her healthcare preferences. She had given me the names of some people to contact in the event of her death, but that was about it. And aside from helping her get a new computer to work on a book she was writing and other occasional legal work, we really weren't in close contact. That changed 3 to 4 years later when she called me to tell me that her lung cancer, and in my mind I went, her what? Had recurred and she would be getting chemotherapy. So I offered to take her to the chemo appointments and was working with her on moving to a different, more accessible apartment. Then one morning in the fall, I got a call from the manager of the apartment building where Jane was living, who told me that she had been found unconscious in her apartment and was taken to the UW hospital. I rushed over to the hospital and found her in the emergency room, intubated and still unconscious. I talked briefly with the doctor and we decided I should come back to the hospital later in the day unless something changed before then. And so about 5 o'clock I came back. Jane was still in the ER, she was still intubated, and she was still unconscious. I talked further to the doctor who wanted me to consent to the removal of the breathing tube. When I asked what would happen, the doctor said, well, she'll probably die. Needless to say, this came as quite a shock. I told the doctor I didn't really know Jane's wishes and what would be in this situation. I needed to give the matter some additional thought. We agreed that I could go home, would come back in the morning, and we'd proceed from there. So I went back home very troubled. Fortunately, I had the list of friends and families that she wanted called at the time of her death and decided that given the gravity of the situation, I was justified in calling them for guidance. I made several calls that night and didn't frankly get a whole lot of sleep. Went back to the hospital the next morning, fully prepared to authorize removal of the breathing tube, even if she were to die as a result. Well, when I came back, she'd been moved to the ICU, and so I went to her room, and there she was, still intubated, but awake and very alert. They removed the breathing tube without incident, but as you can imagine, shortly thereafter we had the conversation. Now, to be fair, we had done just about almost everything right. Jane had prepared a power of attorney for health care. She had picked an agent who she trusted, me, and my identity was made known to the hospital staff. And I even had a copy of the power of attorney document. Since it was in my file, I suppose I should have. But we had missed one very big part of the process. We had not had a detailed conversation about her views and values related to health care and what kinds of decisions she would want made if that eventuality ever arose. Now, to be fair to me, I had tried to have the conversation, but we never were quite able to get it to the top of the list of priorities of things we were working on. Jane's situation is not unusual. In a 2012 survey of California residents, 60% of these respondents said that making sure their family was not burdened by difficult healthcare decisions was extremely important. Yet only 56% of those had not actually communicated what they wanted to their family members. They had not had the conversation. Now, this whole need to talk about decisions related to healthcare, especially end-of-life decisions, is a relatively new historical phenomenon. In 1900, the life expectancy in the United States was about 41 years. By 2000, just 100 years later, it had increased to 78 years. largely due to reductions in childhood mortality and the development of antibiotics. In addition, by the second half of the 20th century, medical equipment and procedures that we take for granted today, the CPRs and defibrillators to restart hearts that have stopped beating, the ventilators to assist damaged lungs in breathing, feeding tubes to provide nutrition and hydration to patients who can't eat or drink on their own, and the various chemical and radiation treatments to fight deadly cancers, all of these have combined to keep the Grim Reaper at bay. However, as is usually the case, these miraculous new devices and treatments have raised a whole host of new and complex legal, medical, and ethical questions. First of all, while we're living longer, this often means we are living with greater degrees of incapacity. Put another way, the good news is we're living longer. The bad news is that the longer we live, the more likely it is that we'll develop Alzheimer's disease or one of the other related categories of dementia, those illnesses that cause an actual physical deterioration of our brains. In fact, by the time we reach 85, 1 out of 2 of us will probably have developed dementia. And what's more troubling societally is that persons over age 85, sometimes called the oldest of the old, are the fastest growing part of our population. Now, our medical technology has also allowed us to save persons with traumatic brain injury from accidents or strokes, but it's not yet taught us how to repair the brain. According to the Global Coalition on Aging, there are over 36 million cases of Alzheimer's disease worldwide. This would be as of 2010. If we don't make significant research progress, by 2030 this will increase to 66 million cases, and by 2050 to 115 million cases. By 2050, the cumulative cost of the care and treatment of Alzheimer's could be as much as a staggering $20 trillion. And most of these cases will be persons who are unable to make their own medical or other decisions for a significant portion of their lives. Now, as is often the case, society, religion, and the law have been scrambling to catch up with these scientific and medical developments. This story is illustrative. Late one evening in 1983, a young Missouri woman by the name of Nancy Cruzan was driving home. She lost control, was thrown from her car, and suffered a severe traumatic brain injury. But she was saved, and I put that in quotes, by the paramedics in the field and rushed to a local hospital. At some point, though still unconscious, she stabilized medically, and without a lot of discussion or consideration, a feeding tube was surgically implanted in her stomach. She remained in the hospital for a period of time and was eventually moved to a state rehabilitation hospital where she didn't improve. While she was able to breathe without the assistance from a ventilator, she did not regain consciousness and was unable to take food or fluids by mouth. The feeding tube kept her alive. After 4 years in this condition and having come to the conclusion that she was not going to get any better, and believing that Nancy would not want to continue living in this condition, her parents, Joe and Joyce Cruzan, approached the state hospital with a request to remove the feeding tube and let her die. Now, this was new legal ground for everyone. In the 1970s, the New Jersey Supreme Court had ruled that an individual, in this case a woman by the name of Karen Ann Quinlan, had the right to refuse unwanted medical treatment, including life-sustaining treatment, and then that right could be exercised by a court-appointed guardian. In the Quinlan case, the procedure at issue was the ventilator, which was breathing for her. The court, after much consideration and going to the New Jersey Supreme Court, ordered the disconnection of the ventilator. However, as it turned out, instead of simply shutting the machine off, they actually weaned her from the ventilator, a procedure that's now very common in the hospital, and she continued breathing. And she lived for more than 10 years, having been kept alive on a feeding tube. Now, Nancy Cruzan's case was different. She was in a condition known as a persistent vegetative state. In essence, while her higher cognitive functions were irreversibly destroyed, Her brainstem, which controls the automatic functions of the body, including breathing and heartbeats, was working. So as long as she received nourishment and fluids, she would continue physically living, albeit with no ability to recognize or interact with people or her environment. Because of the legal novelty and the emotions involved, the hospital refused to authorize removal of the feeding tube without a court order. The Cruzans, with the assistance of a young American with the Civil Liberties Union and Bill Colby, a young lawyer with a Kansas City law firm, petitioned the local probate court to appoint Joe and Joyce as guardians for Nancy and to authorize them to remove the feeding tube. The Attorney General of Missouri intervened in opposition to the request, and the case ultimately ended up in the Missouri Supreme Court. The Missouri court ruled that because there was not, quote, clear and convincing, unquote, evidence of what Nancy would want in this situation, the Cruzans could not remove the feeding tube. The Cruzans appealed to the United States Supreme Court, which agreed to hear the case. In a 5-4 decision in June of 1990, the U.S. Supreme Court held that while Nancy, through her guardians, had a constitutional right to refuse unwanted medical treatment, including the feeding tube, which they held what in fact was a medical procedure, the state of Missouri had the authority and the right to impose a higher evidentiary standard, in this case clear and convincing evidence, in deciding what Nancy would have wanted. Now, while at first this seemed like a loss, this provided an opening for the Cruzans when two acquaintances of Nancy approached them with information about conversations they had had with Nancy that she wouldn't want to live in her current condition. They basically said, look, you don't know us. Well, we were friends of Nancy, and we talked about this, and this is what Nancy would want. And so Joe and Joyce returned to the probate court with this new evidence, and the trial judge ordered removal of the feeding tube. This time, no one appealed. The tube was removed, and Nancy died early in the morning of December 26, 1990. Now, from a legal point of view, the basic problem in the Cruzan and Quinlan cases is that there was no specific proof of what Nancy or Karen Ann would want in such dire medical circumstances. And as a result of these cases, many states, including Wisconsin, passed legislation creating legal documents that could be used to either make decisions in advance, the so-called living will, or to appoint a surrogate decision maker to act in the event of incapacity, what we now call a power of attorney for health care. So while the legislation theoretically solved the legal problems, it did not solve the practical and ethical or religious problems of medical decision making, especially in the end-of-life context. One of the most contentious ethical and moral issues of our day has been the dual question of when life begins and when it ends. The issue concerning the beginning of life has arisen in the debate over abortion. Arguments have been made in many quarters that life begins at conception, or even at the time that the egg is fertilized by the sperm. Certainly, given advances in medical technology that allows prematurely born infants to survive outside of the womb at a younger gestational age, albeit in many cases with severe physical and mental limitations, it has become more and more difficult to pinpoint when the fetus is actually viable, which has been an oft-applied legal test for the beginning of life. But as we have discussed, in recent years, the time of the end of life has been equally difficult to determine. In the past, a person was dead when he or she was dead. The heart stopped beating and the person stopped breathing. However, today, with all of our medical technology, we can often restart a stopped heart. And we can artificially prolong breathing for a seemingly indefinite period of time, even when there's absolutely no other brain function above the brainstem, and even below the brainstem. And then there are those situations where respiration and heartbeat continue on their own, but there is no discernible cognitive activity. In these situations, what does it mean to be alive? And this is further complicated by other developments in medical technology, especially the common practice of organ transplants, particularly heart transplants. When is a potential donor dead for purposes of harvesting his or her organs? If someone's heart is breathing, beating and he or she is breathing, but there's no other brain activity? Is it ethical to turn off the machines that are artificially supporting life so that the transplant can move forward before the organs are no longer suitable? These are troubling questions for families and hospitals alike. Now, in cases like this, many turn to their religious faith for guidance. In 2013, the Pew Research Religion and Public Life Project published a study of the views of all the major religious traditions, Christian and non-Christian alike, on end-of-life care. Well, they found almost unanimous opposition to physician-assisted suicide, with, frankly, the United Church of Christ and the Unitarian Universalists taking a position that this is best left up to the patient and his or her family and doctor. There seemed to be more consensus on issues relating to the withdrawal of life-sustaining treatment, even if such withdrawal would result in death. On the more general question of the refusal of life-sustaining treatment, there seems to be a fairly general accord that persons are not obligated to accept extraordinary treatment to prolong life at all costs. While different traditions articulate this view with different language, they all seem to differentiate between action or inaction that will not prolong life versus that which will hasten death. There is less consensus, though, about what is meant by extraordinary treatment, especially as it regards the withdrawal of tube feeding. To be sure, the medical profession and the courts have pretty much agreed that tube feeding is a medical procedure, in the same sense that supporting respiration using a ventilator is a medical procedure. However, there is an emotional component in the withdrawal of artificial nutrition and hydration. This was the issue that was at the heart of the Cruzan case. The Quinlan case was simply, and I put that in quotations as well, it was simply about turning off the ventilator. As it happened in that case, even though they turned off the ventilator, she continued breathing and was kept alive because she was on a feeding tube. But in Cruzan and Shivo, as well as a case in Wisconsin called Edna MF, all involved the removal of a feeding tube. And this stirred up a lot more controversy. Now, for some persons, removal of a feeding tube conjures up images of concentration camp survivors and starving children in third world countries. It is assumed that if the feeding tube is withdrawn, the person will die in agony. In point of fact, most of the medical literature, particularly the palliative care literature, suggests that the withdrawal of artificial nutrition and hydration at the end of life will not cause any significant pain or oftentimes even discomfort, as long as moisture is placed on the lips and the inside of the mouth. This is because the body generates a pain-numbing ketone as part of the dying process. And in fact, it's common for persons to stop eating and taking fluids at the end of their lives. In fact, sometimes the use of the feeding tube can exacerbate the situation by causing what they call aspiration pneumonia. Yet in many states, Wisconsin included, feeding tubes may not be withdrawn for non-decisional individuals without clear evidence of what they want. In Wisconsin, in order to withhold or remove a feeding tube under the terms of an advanced medical directive, the document must contain explicit instructions regarding feeding tubes. And so this brings us to the final issue, the one raised by the story I shared at the beginning of these marks and highlighted in the video this morning. In recent years, there's been some significant progress in persuading people to sign advanced medical directives, especially powers of attorney for health care. Under something called the Patient Self-Determination Act, upon admission to a hospital or a nursing home, the facility is required to ask if the admittee has an advance directive, and if not, to offer to prepare one for him or her, although execution of the document is not required as a condition of admission. However, as my experience demonstrates, signing the document is not enough. The theory behind the power of attorney for health care is that one is appointing an agent to speak for you when you no longer have the mental capacities to speak for yourself. Now that's fine in theory, but only if the agent knows what you want. If you get into a situation like I found myself with Jane, I had no idea in those circumstances what decision she would want. And so it's imperative that there be a conversation involving the principal, which is the person signing the document, the agent, the person who's going to make the decisions, and ideally other family members or significant persons so that they also know what the individual's wishes and desires are. What are their personal views and values related to health care, both during and at the end of life? But remember, this is not just about end-of-life decisions. Because of issues related to Alzheimer's disease and other dementias and the after effects of strokes or other traumatic brain injury, there could very easily be extensive periods of time when one might be physically alive, but nonetheless incapable of making medical decisions of any kind, from the most mundane, an aspirin or a Band-Aid, to the most complicated, surgery or even turning off the machines. Now, probably the most important question that arises in this whole process is who should be selected as the agent. As a matter of law, this could be pretty much anyone, other than your healthcare provider. But in terms of thinking about who should have this task, I've always suggested there's 4 criteria that need to be considered. First, is the proposed agent somebody who shares your views and values related to health care? Or if they don't, respects you enough that they'll carry out your wishes even if they disagree with them? Is this a person who is able to make tough decisions in stressful circumstances? Is this a person who is tough enough to be a strong advocate for you in dealing with the healthcare system? And of course, and this may sound obvious, but it's not, is the chosen individual willing to act as agent and make those difficult decisions? With the correlative, they have to know ahead of time that they've been appointed agents. Now, once you get beyond those basics, then familial relationships, location, and medical knowledge can also be considered. But I think the factors that I listed seem to me to be the most important. In deciding what kinds of healthcare decisions you want, there's a lot of different things you need to think about. What is your current age and state of health? Nancy Cruzan was in perfectly fine health when she had her accidents. Her decisions would probably be different than Paul Pearson's at his stage in life and his stage in health. So think about yourself. In your current state of health, what would be your goals of care if somebody had to make those decisions for you? What are your own personal and religious views? What's important to you in your life? What abilities, if lost, would make continuing to live less important to you? How would you want your pain managed? What would be more important? Pain control or your ability to interact with your friends and family? And the questions can go on. And it's not just a one-time discussion. Your wishes will change as you age and as your health changes. I'm sure many of you have already signed an advance directive. But have you had the conversation? If you did, when did you have it? What did you discuss? Have you had this discussion with loved ones who are not among your designated agents? Do they know what you want? Is it time for another conversation to update your wishes and possibly update your advance directive? Now, it's easy to put off the discussion, as both Jane and Nancy Cruzan demonstrated, because you can never know. It's easy to put off the discussion, but as both Jane and Nancy Cruzan demonstrated, you can never really know when the time will come when somebody will have to make a crucial decision on your behalf. While this is not an easy discussion, nothing important is easy. There are people who can help you with this conversation to help facilitate it. There's projects going around the state that I can talk with you about if you wish. But I wish for one thing, if you walk out of here with nothing else, consider the conversation.